Good evening. It is time for today's Tax Talk. I'm your host. I'm attorney Stephen Leahy. It is Crypto Tuesday, April 4th, the year of our Lord 2023. There's some more information about Ripple versus the SEC and the battle for crypto clarity and the with regulation. So that's what we're going to talk about today. Won't you join us? Okay, so that's what we're going to talk about today. It is the long version. So anyway, I've been away for a little while, so welcome back. We were in Mexico and Cancun on business, so learned a lot. So we're back. Thanks for joining us. We're going to start where we always start on Crypto Tuesday with our favorite site, coinflip.tech, and where the markets are. And so today, Bitcoin's reached 28,000. So it's up almost over 2.5% today. And look at that, Ethereum's up 5.5%, more than 5.5%. But again, closely matching with Bitcoin. They very well move together. So it's interesting, the move up. I gotta say, I've read a lot about the crypto and what people think about it, what's going up. There are those who believe that crypto is going to zero. And there are those who believe that crypto is going to $1 million very quickly. Which one is true? Well, I guess we're going to find out, aren't we? And because you never know what's going to happen. But there are people who are on both camps who believe one or the other. One of the things that might very well make the difference is what we're going to talk about today, and that's this lawsuit, Ripple versus SEC. Now, we've talked about this lawsuit before on the show, but there's more news today, and I think this is really that important that we should follow this case very closely, because it's going to have a lasting impact on what goes on with crypto, whether it goes to 1 million or goes to zero. So as the courtroom battle between Ripple and the United States Securities and Exchange Commission continues, to grab the attention of the crypto community as well as the world, a legal expert and amicus curiae for the blockchain company shared an explanation of one of the most important legal terms referring to the case, as well as his view on the ruling deadline. Indeed, he offered a detailed interpretation of securities and the investment contract, which he called one of the most misunderstood legal terms in the law. And the Howey test, as we know, that's from the Supreme Court case, the most misapplied legal test or doctrine on social media. I didn't know it's not a doctrine on social media. I think it's kind of not very clear. As well as their connection to the current legal standoff, as he stated in a Twitter thread published on April 2nd. On Securities and Investment Trend, because now that's where we get our news now on Twitter. As he explained, sharing the definition of security from the 1933 Securities Act, a digital asset is not listed, and the software code is not listed, also referring to the cases of the now abandoned Telegram's token, Gram, Kick Interactive token, as well as a decentralized video sharing platform, LBRY's offering of LBC, to drive his point home. Furthermore, he said, and the Supreme Court in the Howey case in 1946 defined what constitutes an investment contract. A digital asset or cryptocurrency, software code, standing alone is not a security. It can be marketed, packaged, offered, or sold as an investment contract, aka a security. As he added, when dealing with an investment contract, there hasn't been a single case in U.S. history where the secondary sale of an asset was also found to be a security. Never. Every altcoin arguably starts out as a security when it's first distributed, ICO or not. When Satoshi, I forget, I never could pronounce that one, was the only miner of Bitcoin, or one of a few, and had offered 100,000 Bitcoins for sale for $100,000 US dollar. It would have been an unregistered securities offering. Earlier, discussing the possibility that Judge Torres would make a summary judgment ruling soon, Deaton said that the deadline for her decision could range from hours to months, and that based on her earlier cases, 2 months following a expert's decision would be a waiting time, as he said in a tweet on March 31st. There is no deadline of today for her to rule. The decision could come out within the next hour, or it could take another 30 to 60 days. Based on previous cases, Judge Torres has issued her ruling on summary judgment within a couple of months of the expert's decision. Considering that, a Feinbold earlier reported, the judge issued her ruling on both parties' Dobert motions to preclude expert witnesses' testimony on March 6, 2023. That means the crypto sector could wait at least another month for the Ripple versus SEC lawsuit to end. The ripple effect of the case. As a reminder, pro-Ripple lawyers have voiced their opinion for that the above decision could prove disastrous for the finance watchdog summary judgment motion, signaling out an exclusion of one of the specific witnesses who was supposed to testify, and why people brought the XRT token as fatal to the SEC. Meanwhile, the outcome of the case is predicted to have a major impact on the price of XRP. The token recently displayed the opposite response to TV personality Jim Cramer, because TV personality Jim Cramer is always right, as we know, seeming to voice a belief that the Securities and Exchange Commission would lose the lawsuit after all. As things stand, XRP is currently changing hands at around 52 cents, recording an increase of 0.28% on the day, as well as gaining 1,515% over the previous week, adding up to a 36.69% advance on its monthly chart as of per data retrieved on April 3rd. So that's interesting. So it looks like people are anticipating that they're going to win the case, that the XRP, the judge is going to say it's not a security. At least that's what it looks like. That's what they think. We don't know what's going to happen. Here's another case. There's lots of cases I wanted to talk about today. I'm not going to have a lot of time to get to them, but I wanted to at least bring them to your attention. And they're listed in the description so you can read them. Okay, and I think they're all SEC charges Beasley cryptocurrency platform for violating securities law. Now, this was today, March 30th. This is published March 30th. Securities and Exchange Commission has charged crypto asset trading platform Beasley.com and its executives for failing to register as a national securities exchange, broker, or clearing agency. The company's founder and the company he controlled, Beasley Digital, were also charged with raising $8 million in unregistered offerings at the Beasley token, with the owner misappropriating at least $900,000 for personal use. As of publication time, Beasley.com has ceased operations. So my point, I wanted to bring this case up because they're still bringing cases, right? The Ripple case hasn't been decided yet, but the SEC is still bringing cases against other platforms. Here's another case that I thought was interesting. This case is about, or this story, I should say, is about a Freedom of Information Act request, and how the SEC has not been responsive to this request, to the Freedom of Information request, concerning information about the SEC and Morgan Stanley, J.P. Morgan. And what they had to do with the Ripple lawsuit. A member of the XRP community filed the Freedom of Information Act request back in early August 2022 regarding communications between the U.S. Securities and Exchange Commission and banking giant J.P. Morgan involving Ripple Lab and XRP. In a new update, Ashley Prosper shared that the recent continues to be delayed, that the request continues to be delayed. Prosper is seeking disclosure of an SEC communications with JP Morgan about Ripple and or XRP. The current response letter states that the SEC has recently reviewed the search results, and is now reviewing them. Apparently, there are a large number of records that require confidential treatment, the agency email reads. Based on our initial review of records, it appears that a large portion of the records will require that we engage in the CT substantiation process, which involves records for which confidential treatment was requested at the time of their submission. Engaging in this type of consultation will add approximately 60 days to the review time. So they say that they're just delaying. They're going to make them bring a lawsuit. They don't want to give you that information, even the way it's going, that information won't be out before the Ripple decision comes out. So I don't want to read that whole article, but again, it's in the description. Feel free to read it. It's interesting. Here's another one. Cryptocurrency companies should expect more SEC enforcement in the near future. So again, they're taking all these action. Remember, the SEC chairman has said that only Bitcoin is not a security. All other Bitcoins all other cryptocurrencies are securities, and he wants to regulate and actually eliminate them. Because the regulation would mean that they can't trade them on any platform. The Securities and Exchange Commission has been increasing its enforcement actions against cryptocurrency companies and individuals in recent years. In 2022, the SEC brought 24 litigation actions in federal courts and 6 administrative proceedings against cryptocurrency companies and individuals, a significant increase over the previous years. During 2022, the SEC charged a total of 79 defendants or respondents in cryptocurrency cases, with 29% being firms and 71% individuals, generally the owners of those firms. Nearly half of the 30 enforcement actions brought that year involved initial coin offerings, and over half of those included allegations of fraud. And then they cite some cases where the SEC charged the defendants for those roles in raising over $10 million through 2 fraudulent and unregistered digital asset securities offerings. And then another case where the SEC charged Blockbit's Capital and its co-founders with conducting fraudulent unregistered securities offering. Additionally, the SEC also brought a case for insider trading and market manipulation. So anyway, I just wanted to bring these cases up there. Again, it's in there. The Howey case site is in here. Most of these enforcement actions hinge on whether cryptocurrency investments or platforms and their derivatives are considered securities under the Howey test, as defined by the U.S. Supreme Court. Mr. Gensler, this is the SEC chairman, is pushing to hold the cryptocurrency firms to the same rules that apply to stock and bonds, rather than write a raft of new regulations for the cryptocurrency sector. Since 2018, the SEC has brought or settled more than 90 lawsuits related to cryptocurrencies. More than 30 have come during Mr. Gensler's time in office. The SEC chief has said that the vast majority of cryptocurrencies are securities, like stocks and bonds, that should follow the agency's rigorous disclosure requirements before being sold on the investment public. So wherever you stand on this, whether you think there should be more regulation or less, it really doesn't matter, because it depending on where they come, I think it's going to be the deciding factor, whether crypto is going to survive. My own opinion. Now, I could be totally wrong, and maybe they come against it, they treat it like securities, and it still thrives because of its inherent value. Because crypto and blockchain has inherent value. Are those powers like JP Morgan, Chase, and SEC and other regulatory bodies battling to get rid of it? I think that that's in the cards. They're trying to get rid of it. Again, whether they can or not is a different matter. And let's hope that they can't, because I think, I'm all for freedom. And I think blockchain and crypto offer freedom. That doesn't mean it will deliver. I thought the internet would deliver much more freedom. And in fact, in many cases, it has given us less freedom in many cases. And so you never know what will really happen. Even the promise of freedom is there. and I'm all for pursuing that promise of freedom. If the government and the powers that be try to take it away from us, maybe we can fight that, and fight this regulation. I'm not for these platforms taking advantage of people. On the contrary, the whole beauty of crypto maybe is that we don't need these platforms because it's supposed to be decentralized. And one of the reasons why these platforms are trying to centralize crypto, so they're holding everybody's crypto. If you held your own crypto in your own wallet instead of in one of these exchanges, maybe that would be better for everybody. And maybe that's really the promise of crypto. Just my little bit of editorial there at the end. So that's what I think. But we'll be watching this case very closely. I think it's interesting. There's supposed to be a decision within the next 30 to 60 days. And we'll see. And we will report on it here. So thanks so much for joining us. Remember to like and subscribe. Like and subscribe. We need your help. So please like and subscribe. And remember, if you have an IRS problems, if you owe the IRS any money, if you have unfiled tax returns and you don't know what to do, the first thing you should do is get a copy of my book, Deal with Your IRS Problems Today. Go to freeirsbook.com. That's freeirsbook.com. Get your free copy. I will pay for the printing if you pay for the shipping and handling. Again, it's under $10 for the shipping and handling. And it really doesn't even cover the full cost with the book, the shipping and handling, and all of the free bonuses that I include in there. And you'll see all those at freeirsbook.com. So go to freeirsbook.com, get your free copy. So thanks so much for joining us. I appreciate you being here. And we will be back tomorrow with more IRS news. And I hope you can join us then. Until then, God bless. And now we are now out.